Please, Lord.
Yes, yes.
Lordship, I pray for listing of a matter. Tomorrow, Lordship, thing is that there was an interim suspension of the sentence for 1 month. On 25th of April, the order was passed. We thought the registry, it was directed that matter to be listed after 4 weeks. We thought the registry will be listing the matter. We pursued with the registry. Now they say that mention will be required. Tomorrow, 25th of May, the 1 month period will expire. That is why, Lordship. Obliged.
May it please, Your Lordship. Lordship, this is a bail application and a criminal appeal. I filed it on 16th. Maybe listed on Monday, Friday.
Not Friday. Monday.
Monday. Obliged.
May I please, Lordship? I'd like to mention item number 11 and 12. Lordship, Lordship, the learned amicus curiae Mr. M. Hassan is out of station. Lordship,
No mention memo.
Lordship,
For
he has been out of station since Friday. Lordship.
Jahan
Last night, I was apprised of, but
on request made on behalf of N. Hassan Learned Amicus Curiae.
yeah.
Is the matter after 3 weeks. Same order item 12.
Obliged.
Item 1 of daily list, admission.
আমাক নিদিয়ে এনেকে কচোন কপি নিদিয়ে ৰে
May I please, Lordship? Matter is appeal against conviction under NDPS Act, Section 22C. Judgment is on 9 March.
Okay. You are Mr.
M. Pathak.
Hurt M. Pathak, when the calls for that which for yes. Yes, not the additional people. Appears on behalf of
Respond number 1,
the respondent, respond number 1, sole respondent.
sole respond.
Missed upper bones.
Obliged.
Two, order.
Make this your Lordship. Lordship, I have received the paper book. Paper book is ready. Can be listed for final hearing, Lordship.
Even I've got my paper book.
So date may be given, Lordship, because all the evidence are of hearsay evidence. So
Hurt MS Hardy Majumdar. We also heard MS as Jahan and the decision. Paper book is ready. List the matter for hearing. When do you want? After month?
yes, Lordship.
Today is 24th,
24.
24th of May,
27th June.
Fine, Lordship.
June, Lodge.
Highly obliged, Lordship.
3,
3 is withdrawn.
May I please, my lord, here, my lord, the paper book is received, my lord, in the month of March. And my lord, the matter is ready for hearing, my lord. So my lord, submission is that if your lordship is pleased to fix the matter in the month of June, my lord. Since he is a student, my lord, of age 20 years.
Okay, heard Mr. Edhar.
B. Borua, my lord.
My lord, I am Mr. Edhar. I was engaged as amicus in this matter, but Mr. Borua is appearing, so my name may be struck off.
Heard B. Baral and the council for the applicant. Also heard as Jahan and she. Paper book is ready. List the matter for hearing in the month of June.
Yes, last week of June, my lord. Possible.
The last
Any date, my lord, then it will be convenient.
last week of June is really difficult.
29th is a holiday, otherwise,
Then summer vacation comes.
Then, my lord, can it be on 22nd of June, my lord?
Okay, in the second.
22nd June.
Registry is directed to delete the name of Mr. Edhar and the amicus curiae.
Applies.
Obligation.
4,
May it please your lordship. Here in this case, I was directed to take steps on respondent number 2, lordship, but due to my mistake, lordship, I could not take it, lordship.
No.
I may be allowed 2 days time. I will take steps on respondent number 2.
Okay, heard Mr.
Yeah, Ahmed.
A. Ahmed, learned counsel for the applicant. Also heard as Jahan and addition to the Assam. LCS have come.
LCR come.
LCS have been received. Registrar is directed to prepare the paperwork. In the meantime, Mr. A. Ahmed, learned counsel for the applicant. No. The applicant is permitted to take first steps for service of notice on the respond number 2 by registered post
Registered post with AD.
with AD within a period of 1 week from today. This is the matter after 6 weeks.
Obliged.
5,
In this case, Lordship, service is not complete. On respondent number 2, matter relates to POXO matter, so we may be allowed to take first steps, Lordship, we will take.
But A. Ahmed, learned counsel for the applicant. LCRs have come.
Yes, yes, my objection is also on record.
Also heard MS El Jahan and additional PP Assam. LCRs have been received. Registry is directed to prepare the paperwork. In the meantime, applicant is permitted to take first steps
Right.
for service of notice on the respondent number
2,
by
registered,
registered post AD within a period of 1 week. This
I will be considered after service of notice. Lordship.
matter
in-
after 4 weeks.
in
Now,
I-
6 weeks.
I is pending in I that of
That,
the.
that will automatically will take it up.
Obliged.
To cook and dance.
6,
Six, we have filed our objection, madam.
LCRs have come.
Is your, isn't it?
Lordship, my senior, can you please give me 2 minutes? My senior is just down there
Where?
in the table.
What?
My senior, he's not there in the court. Can you please give me 2 minutes? I'll let him know that.
Pass over for the time being. Make it
Why
pass
don't
over
you
for the
ask
time being.
for passing it over for the time being?
Yes.
After some time, next case.
Okay, thank you.
7,
May it please your lordship. I is for continuation of delay, your lordship, for 269 days.
269. Any objection?
Notice may be issued, your lord. Or registering.
She has no
Or it may be
objections.
condemned, your lordship.
Objection, let it be.
Let it be
Heard
condemned, your lord.
Mr. You are?
A Das on behalf of the legal aid counsel, Mr. J Das, your lord.
Heard Mr. A. Das.
Yes, your lord, on behalf of Mr. J Das.
Council appearing on behalf of Mr. J. Das, then the legal aid council for the applicant. Stop. Also heard MS B. Boyan and additional PPS. By this application, the applicant is praying for continuation of 269 days delay in filing the connected criminal.
Yes, sir.
Stop. We have considered the cause shown in the application and we are satisfied. MSB Boyan, learned additional BP has also no objections. Accordingly, the delay of 269 days is condoned. I is disposed of. Registry is directed to number the criminal appeal and list the matter in its usual course.
Much obliged, your lordship. Thank you, ma'am.
8, hearing.
Lordship, kindly take up the matter after some time, Lordship, some accommodation, Lordship. I'll do it, someone.
Why?
Lordship, it's a hearing matter, Lordship. It will take some time, Lordship. One matter is there, that is, it may clash, Lordship. Only for that reason.
I've gone into that matter, and Lordship can take it up after some time, after finishing 1 or 2 matters.
Oblige.
9,
He has received a paper book, our office has not provided, but I have gone through his paper book. I'll do from the LCR, Lordship.
There's a
Stop, better?
difficulty
My lord.
going through LCR and the paper book. There's a lot of dislocation. Why don't you get your paper book?
I'll get it xeroxed and matter will be taken up tomorrow. It's not, Lordship, they could not find in the office.
You have been given, but you have received. it.
Lordship,
Your office has received. it.
unless the copy is served, it cannot be like others, that has to be served, my lord.
Yeah, Mr.
B. Bhagavati.
Heard Mr. B. Bhagawati.
Day after. Short matter.
Request made by MSB Boyan. Additional PBS. Is the matter. Tomorrow is what?
Tomorrow is 25th. Thursday, my lord, can be taken up if it comes in the supplementary.
30.
Lordship?
We'll have it on 31st. 31st.
Then
Is there an objection to us?
May it please your lordship. Here, the appellant was convicted under section 302. And incident is of 2013/7/1997. And FIR was lodged on the next day on 14 July 1997. Here, prosecution case is that after committing the offense, the accused appeared before the police and surrendered himself along with the dao, that is the weapon. And accordingly, on the next day, the uncle of the deceased was informed, and thereafter he lodged the FIR. Here, your lordship will find there is no witness who has seen the incident. And there is, in my humble understanding, lordship, although the learned trial court has convicted him on the basis of circumstantial evidence, but I will place from the judgment itself. In the judgment itself, the point which he discarded, again, while framing taking the circumstances, he has taken those circumstances, which has caused prejudice to the appellant. Because once it is that circumstance is discarded, he cannot take it while framing those circumstances, lordship. And on that basis, he was convicted. Although there is, lordship, confessional statement is there, 164, and the learned session judge has rightly discarded it because he was not given sufficient time for reflection. There is no observation that he was given sufficient time because after arrest, he was immediately produced before the court and his statement was recorded. And there are other discrepancies also because he was not provided legal assistance while recording the 164. So that part is rightly discarded. And only thing is here, we have to see, your lordship has to see that whether the circumstances which is relied on by the trial court are proved circumstance or not, lordship. That is the case here in this case. FIR, your lordship will find page 3. This is lodged by the uncle of the deceased after getting information from the police, lordship. On 14 July 1997, it was lodged. Humble submission is that around 7 p.m. on 13/7/1997, Sri Bolia Mura, son of late Lakhani Mura, resident number 1, Kotkotia village under Bukajan police station, hacked my nephew, Manik Soikia. So Manik Soikia is the deceased, lordship, son of late Jugen Soikia, to death at my paddy number 1, Kotkotia village field over the issue of blocking a irrigation channel to the paddy field. I have learned that after killing my nephew, accused Bolia Mura has surrendered to the police in the outpost. It is therefore prayed to take necessary action again after investigating into the matter and oblige. So this is the FIR, and then your lordship will find the case was registered under section 302. Charges were framed that your lordship on page 5, 302, under section 302.
Yes.
And then evidence, your lordship will find PW1, page 8. He is the informant. I know the accused Bolia Mura, who is hailing from our village. They are in the paperwork, your lordship will find there are some mistakes in the translation probably. So if your lordship feel that these are minor discrepancies, your lordship can overlook it. There are some there.
Original is in SMS.
Yes. I know also this is Manik Soikia, who was my nephew living separately. He had eligible of his own. He was a cultivator. On 13/7/1997, the incident took place at a pathar field of 1 number Khatkotia on way of 1 kilometer from my residence. On that day, I was at home and at about 10:11 p.m. The incident took place while I was at shop.
10:11 PM.
Lordship. In FIR, he says 7 p.m. And in other GD entries also there, that also your Lordship will find that it says 7 p.m. This time is important because Lordship here, the incident occurred at 7. And from the evidence of PW2, who is wife of the deceased, your Lordship will find immediately she went there. She found him alive. And thereafter she went to inform others and she never returned. Had there been, he been given Lordship some medical treatment, he would have probably survived. That possibility is also there, Lordship, because the conviction is under section 302.
Original is in English only. Original is not in Assamese. Only that it was handwritten, that was typed out, not translated as such. It's written here 11 p.m. only.
10:11 p.m.
Uh-huh.
It is written
10:11.
10:11.
10/11 p.m.
The incident took place while I was at shop. Page 9, Lordship, I am reading. The IC Borpathar OP along with staff came to my house, informed me that the accused Balimura has appeared and stated that he has killed Manik Soikia with a dao. Then IC instructed me to go to Thana for identification of the dead body. Accordingly, I went to Thana with IC. In Thana, I saw the accused Baliamura in Thana lockup. IC asked me what relation do I have with the deceased. Then I told that he was my own nephew. Then I also asked the accused about the incident, who replied that he had killed Manik with a dao. Police seized one dao with bamboo nail from the accused person in presence. Exhibit 1 is the seizure list. Material exhibit A is the seized dao. So here your Lordship will kindly note that here first dao was seized from the spot. And second dao your Lordship will find that was recovered from the possession of the accused. And my case is that, Lordship, there was some altercation and both were having dao. So he has not taken undue advantage. For that, I am placing this fact, Lordship. Then I, along with accused, took to the PO and saw that the dead body of Manik Saha was lying downward, who was completely dead. I saw the injury on head and feet. The accused led the police and me to the spot and showed the dead body, who was identified by me. Police also seized one ever-ready torch light and with 2 batteries and 1 dao with bamboo nail about 2 feet in my presence at the spot. Exhibit 2 is the seizure list, is my signature. Material exhibit B is the seized torch light. Material exhibit C is the seized dao. Police held the inquest over the dead body of Manik Saha on being identified by the accused. Is my signature. Due to midnight of the day, the dead body was kept on the spot with the guard of police and myself. On next day in the morning, the dead body was taken to the Thana and also accompanied the dead body. Then I submitted an Azahar to the OP on the next day, that is 14/7/1997, which was written by myself. Police recorded my statement and the dead body was sent to Civil Hospital Difu for postmortem. The dead body after postmortem was handed over to us. I did not know any reason why the incident took place, but I know that Manik Saha went to the field Pathar to place chop for catching fish. So here your Lordship will find that motive part is absent. In the other part of the evidence also your Lordship will find that motive is absent. And why I am placing this, Lordship? Because the learned trial court has convicted me on the basis of circumstantial evidence. And your Lordship knows that if the case is based on circumstantial evidence, that motive assume importance, Lordship. In cross, Lordship, there 1.5 kilometers is situated my house and my nephew. I was not informed from the deceased house, but I was informed by the police. Manik's house and the accused house is very nearer. I know the accused from the long time. The accused works as cultivator as he has own land. I do not know that accused was hard of hearing. Now PW2, page 11. I know the accused Boliamura as his residence is our very nearer. The accused was living at his house by working in the field. Sri Nogen Soikia, the complainant who is uncle of Manik Soikia, the incident took at about while I was living at my residence with my son. The deceased husband was also with us before the incident took place. The incident took place at Paddyfield, in between the accused house and our house. The deceased husband went to place Khoka to catch the fish at a near distance. He shouted at Bokuli Bokuli after half an hour of his going to placing Khoka. Then I ran towards the place where I heard the sound, and I saw that my husband was lying on the ground, senseless, and I saw injuries at 3 places, namely feet, head. Then I saw the accused Baliamura running towards his residence with a dao. Then I ran towards the house of our neighbor and told them that my husband was lying senseless in the field. Then the house owner took me to my house. Then police accompanied with the uncle of the deceased Manik Saha and told me the description of Boliamura. I did not go with police to the spot at night. On the next day, police came to my residence and recorded my statement after taking the dead body for postmortem. There was no quarrel between us with Boliamura, and we happened to come to his residence on the day of occurrence. The house of Baliamura and our house was very nearer, and we came to our residence each other. My house was killed by my husband was killed by Boliamura while I saw at the spot, and there was no single person except me on the spot after occurrence. It is not a fact that I did not see accused Baliamura on the spot. The aged field of Baliamura and ours are very nearer. He did not work in the field. I did not inform his uncle, namely Nogen Soikia, because it is far distance at about 1.5 kilometers, and also at present time, I could not go as omen. The accused killed my husband with a dao, which is identified by me, Exhibit A, by which the accused committed the murder. Now, PW3, page 14. I know the accused as Baliamura at the dock. I know Nogen Soikia, the complainant. Nogen Soikia, I knew the deceased Manik Soikia. The incident took place at about 6-7 years back at about evening time. I get information about the incident on the next day through Horen Soikia to the effect that the Manik Soikia was murdered by Baliamura at the paddy field. I went on the next day to the field of Manik Soikia and saw the deceased lying on the paddy field with physical injury on his leg and hand. And Moni Gogoi, Sokro and others along the police were among arrived on the spot. So
Let
here
us have a look at the LCR.
Lordship.
This is very badly typed out.
Yes. PW3, I'll just read out from here. Lordship can take it, otherwise the Lordship. It's in English only. Or I'll read it.
Let us see. Badly, can't understand.
Okay.
here in paperwork, Lordship, PW from PW3, what I can see, Lordship, it is, he said only leg and hand injury he has seen.
Can't understand. It is worse.
But it is readable. I mean, But-
Give it to her. Give it.
I'll just try to read it. Otherwise, yes, the writing itself was bad. I mean, the language was not good. I could read it somehow, but let's see. I went to the next day to the field. I'll just see it. I went on the next day to the field. Yes, not very good. Field, and then there is something spot. Acha. Of Manik Saikyan saw the deceased lying on the paddy field with physical injury on his leg and hand. And Moni Gogoi and Charu Bora and Etukiba, something along the police were already arrived on the spot. The accused was not present on the spot, but reported that he had asked,
Already. He had already
requested to the police post
reported.
or reported to the police post. Acha. When he went to see, the accused was not there on the field. The
Where was
police
where's-
inquired and seized the bamboo nalda and pick up that battery torch and a 2 battery torch on the spot in my presence, and Sharon signed as a witness.
So he went to the spot on the next day of the occurrence and he found only injury on the leg and hand.
It's leg and
And
hand,
he is
yes.
not declared hostile, so his evidence is binding on prosecution. So prosecution now have to say then how the injury on head of the deceased came and when came. Lord. Because on the next day he only saw that injury is on leg and hand.
Yes, proceed.
And PW4, Lordship, page 16. I know the accused.
Who's PW3?
PW3 is Moni Gogoi. He is from same village, Lordship.
Villager. And PW4?
No, PW3 is also from same village
4.
and 4 also, Lordship, villager, co-villager.
Yes.
PW4, Lordship. I know the accused in dock as he hails from my own village. I also know Sri Nogen Soikia and deceased Manik Soikia. The incident took place in 1997. I got information at about 8:30 a.m. in the next day morning about the occurrence of the incident. After receiving the information, I went to the paddy field of Manik Soikia where I saw the dead body of Manik Soikia. I did not see any injury on the body as because the police was bind over the dead body. Police has bind over the dead body. The Baliamura is any head loose a murderer of Soikia. And the accused Baliamura was not present on the spot as he was reported to be at the PS. Police inquest over the dead body of Manik Soikia. Exhibit 3 is the inquest report and 3
Jahan, you read this last part. The Balia Mura is any head clues.
Yes, this is what is written even here. I can read that only. Baliamura is my head loose, cannot be any meaning, a murderer of murderer of
I don't understand how to do this.
Hard to be a murderer. Hard to be a murderer.
hard to be a murderer.
It will be also hard to be a murderer.
Yes. Any
The
name?
Baliamura is hard to be a murderer of Soikia.
This is what is correct. Heard to be a murderer.
Hard to be a murderer.
He heard that he is a murderer.
Hmm.
Baliamura is heard to be a murderer of Soikia, and the accused Baliamura was not present on the spot as he was reported to be at the PS. And thereafter he signed the inquest report also. And PW5. He is also co-villager. I know the accused Sri Baliamura on the dock, whom my our village. I also know the deceased Manik Soikia, who was also of our village. The incident I cannot remember, which happened in the last 5-6 years. The incident took place on the day before I heard. I heard on the next day from the uncle of the deceased. It was narrated that on the last date, the deceased was lying on the paddy field caused by the accused Baliamura. I reached the spot on the next day while I received the information. I saw that the Manik Soikia by dying injured
Was
lying over. Manik Soikia was lying injured on the field and also found him dead. I also saw Sri Ajit Fukan, Nogen Soikia, complainant, and Moni Gogoi was present on the spot. Police reached on the spot before our arrival. At that time, Baliamura was not present there. It is informed by Nogen Soikia and police official to the effect that Baliamura was already present in the PS. The police seized after seeing the Meland, one Eveready torchlight bamboo null dao at the spot and seized in my presence.
What is this melon?
The
The police sees after seeing the. After seeing the. If you can. After seeing. The police sees after seeing.
Better get it typed out properly. Better get it transcribed properly.
Difficult to comprehend, but seeing the MELEND and one Eveready torch seized bamboo dao at this spot.
Others also all like this.
Yes, Lord. And only 2 witnesses are there. More. Total 9 evidence of 9.
The
I
next is
already-
the doctor.
That's fine, but then how do we proceed like this? Just makes no sense.
Because in the vernacular it is there, Lord.
Is it in English or vernacular?
It is in English, Lord.
They typed
is,
it simply. That's
There
it.
itself. So paperwork section cannot change that. That is the difficulty.
The vote is something different, but we cannot make out.
Wrong typing also there, isn't it? Like on top, he said, I saw the Manik Saikia by dying injured. It should be lying.
Lying here.
Line.
Somehow the L seems to be D, so it was typed out like that. Lordship can see that Mullen word, if the Lordship can make out something. The last paragraph of this. First line.
Any word called Mullen?
I don't think so. I don't know. Let me check out.
Either English, Hindi or Assamese.
Assamese, though, it's not, I don't think so. Melon.
It's not mine. This is the one. This is the mine. The police seized after. Seventeen. What can it be? Huh? Materials. Huh? Material. But it doesn't. I don't know. But it is that material. How do we go about this now?
I have take lordship in the judgment where evidence of PW5 was discussed. It is not discussed in there, lordship. You will find page 41 of the paper book, paragraph 11. Evidence of PW5 is discussed here.
Page
41, Lord. Paragraph 11.
Simply wrote, police seized one Eveready torchlight.
We can just proceed with. Yes, proceed.
So from his evidence, it is lordship, the prosecution proved that one torchlight and one dao with bamboo null was seized by the police from the spot. Lord. And next evidence, your lordship, you will find PW6, that is page 20.
Is also,
He is a policeman, lordship.
yeah, are you?
No, lordship.
Oh.
He was there when the accused appeared at the police station. Lord.
Yes.
On 13/7/1997, I was at Thana on duty of Borpothar OP. The accused Balia Muria appeared before the OP Borpothar. As I was on duty, IC told me to accompany him to the PO. IC took us to the PO and could not, it is illegible, as because the night falls and the incident took, I guard the dead body in the right place at 1 number Khotkotia. So here your lordship will find that IC took us to the PO. So it was the IC who took the accused to the PO. So accused has not led the police party to the dead body, lordship, because the learned trial court has held that the accused has led the police to the dead body. From this line, your lordship will find IC took us to the PO, not the accused. IC came back to Thana next day morning. He came to the OP and inquest over the dead body in presence of the local people, and we took up that dead body to Diffu Civil Hospital for postmortem. The relatives and brother of the deceased came with the dead body and identified deceased as Manik Saha and handed over the dead body at Diffu Hospital for disposal. Because I did not see killing of the deceased by Balia Mura. So this one. And PW7, page 22. On 13/7/1997,
Done my copy.
this in this case, lordship, half trial was done by the ADC Diffu, lordship. Earlier, he used to exercise that judicial power, lordship, and subsequently, the judgment was passed by a judicial officer.
Proceed.
Page 22. In the first part, your lordship will find in the court of PC Das, AC Diffu, top your lordship will find. On 13/7/97, I was at Borpathar outpost as constable. On that day, I was discharged duty. The accused Baliamura happened to be to the OP at about 11:30 approx and appeared with a dao in his hand at Borpathar outpost. I informed IC about to the effect that a person appeared in the OP with a dao. I asked the accused his name, who replied that his name is Balia Mura. As directed by IC, I detained in the OP. I detained the outpost lockup. After the time is over, I released from the duty. I was released from the duty. Cross. The accused came on an incident warmer. I did not ask him about the incident that he has committed any crime.
1 minute. Okay, accused came.
Indecent word.
Manner.
Manners. Indecent manner.
Is it indecent?
Should be space. Not that indecent. Indecent. So from his evidence, your lordship will find
Accused came in
a indecent manner.
a
So the accused appeared before the police with a dao, lordship. As he was in indecent manner, so he was put behind the bar. So nothing was asked. Even he admitted that I did not ask him about incident that he has committed any crime. Whether he has committed any crime or he has witnessed any incident, nothing was asked to him. Just put him behind the bar. page 24, PW8. He is the doctor who conducted postmortem examination. On 3/8/1997, I was at Defoe Civil Hospital. On request of inquest report from police, the superintendent of Defoe Civil Hospital instructed me to perform postmortem of male dead body on 14/7/1997 at 1 p.m. I have done postmortem at 3:45 p.m. and dead body was identified Oren Soikia and Prahlad Soikia. They are not examined as witness, Lordship. On examination, I found a cut injury on left leg and left thigh and right lower temporal margin of head. I found no disease or deformities in the body. There is evidence of fracture on left ear and Fedius dislocation of left forearm. It is illegible wall body figure and there is no evidence of presence of rigor mortis. There is deep cut injury of left side, leg size about 10 into 5 cm into and 3 cm in deep and deep cut injuries at left size 12 into 12 cm deep 4 cm. The deep cut injury over temporal region size 2 into 2 cm and collapse of brain matter. In my opinion, the deceased died due to acute sudden collapse of brain matter and deep cut injury over right temporal. Exhibit A is the postmortem report. Signature is mine. Cross. I was alone. I alone did postmortem and used to help me by the helper. The cut region was cut region with sharp weapon. From his evidence, your lordship will not find the time of death. Whether he died immediately or he died subsequently, that part is missing, lordship here. PW9 is the IO, lordship. Page 26. On 13/7/1999, it would have been 1997. I was in charge of Borpathar police outpost. At 11:30 p.m. on that day, a person, Bolia Mura by name, came to the police outpost, taking a dao in hand and told me that he had inflicted cut injury to a person called Manik Saha with that dao. To that effect, I made an entry in GD. The GD entry number 202. Exhibit 5 is the GD entry number 202 and exhibit 51 is my signature therein. Then at 11:50 p.m. I seized Nogadao fitted with a bamboo handle brought by the accused in front of witness. Exhibit 1 is the seizure list and exhibit 11 is my signature therein. After that, at 12 in the midnight, we started off to the place of occurrence. At 12:30 a.m., we reached the place of occurrence. We took the accused there along with us. Here also your lordship will find, we took the accused there along with us. So accused has not led the police party to the place of occurrence. And he showed us Manik Saha lying on the ground amidst the field with cut injuries made with a dao. Apart from the accused, deceased person's uncle Nogen Soikia also accompanied us to the place of occurrence. At that time, we found Manik Soikia lying dead. Deceased person's uncle Nogen Soikia identified the dead body. The inquest could not be held as it was late in the night and there was darkness all over. We returned to the police outpost after making arrangements to keep an eye on the deceased. The following day, I again visited the place of occurrence and held inquest on the dead body in presence of the witnesses. Exhibit 3 is the inquest report and Exhibit 3-4 is my signature therein. Upon finding a 2-cell torchlight and a dao lying beside the dead body, I seized the same in presence of the witnesses. Exhibit 2 is the seizure list and Exhibit 2.4 is my signature therein. After that, visiting the place of occurrence, I recorded the statements of witnesses. Then I prepared a sketch map of the place of occurrence. Exhibit 6 is the sketch map and Exhibit 6.1 is my signature therein. Then the dead body was sent to hospital at Difu for postmortem examination. On 14/7/1997, deceased person's uncle Nogen Soikia lodged an Azahar with the Borkothar police outpost in connection with the incident. Upon receipt of the Azahar, I made the GD entry by number 214 and sent the Azahar to Bukajan police station for registering a case in this regard. On the basis of the said Azahar, Mukul Kakoti, the officer in charge of Bukajan police station, registered case number so-and-so. Exhibit 4 is the Azahar. So-and-so is signature. I have recognized the Exhibit 4.3 is the signature of Mukul Kakoti, officer in charge of Bukajan police station. Then I got the medical examination done on the accused and sent him to the Honorable Court on 15/7/1997. As the accused confessed his guilt, I made a prayer before the Honorable Court for recording his confessional statement. On 16/7/1997, so this date, Lordship may kindly note, because there are discrepancies in date also, therefore the 164 was discarded by the learned trial court. On 16/7/1997, the Honorable Court recorded his confessional statement. Thereafter, I collected the postmortem examination report. After completing the investigation, as sufficient incriminating materials were found against accused Bolia Mura for committing an offense punishable under section 302 IPC, and therefore I submitted the charge sheet against the accused. Charge sheet number so-and-so, cross. When I asked the accused the reason behind the killing, he told me that a quarrel had taken place following the watering of the field and that he had killed the victim deceased as a result. The accused said that the dao he had brought to the police station belonged to him. As informed by the accused, around 7 p.m., the accused had a quarrel with the deceased at the field itself, and he had killed the deceased at that place. None else had witnessed the incident. And now your Lordship will find the confessional statement of accused, page 70. It starts from page 70, and your Lordship will not find that he was given sufficient time for reflection, because there it has to be written there that sufficient time is given, Lordship. And his contents, your Lordship will find page 76.
Yes.
At around 5 p.m. on a Sunday, I do not remember the date, the deceased Manik Saha and I had a quarrel over water for the paddy field. So here time is 5 p.m. The said deceased would not allow the rainwater to enter my paddy field. When I tried to take the water towards my paddy field, the said deceased person attacked me with a dao with an intention to kill me. I knew he wanted to kill me because he had earlier said that he would kill anyone who tried to take the water. At the time of the incident, when the said deceased person attacked me, I too had a dao in my hand. I hit the deceased person with the sharpened side of the dao on his leg. The deceased fell to the ground there, and then I left the said deceased there where he had fallen and surrendered myself to the police station at Satipur Thana. I also surrendered the dao with which I had hit the said deceased person. I did not intend to kill the said deceased person. When I hit him on his leg with the dao, I expected that he would be wounded and the mark would remain. I did not expect him to die. I have nothing more to say. So this is the confessional statement, Lordship. And now if your Lordships turn to page 46 of the paper book, from paragraph 21, Lordship, the reasoning of the learned trial court is given, Lordship, for conviction.
Yes.
Paragraph 21. Exhibit 8 is the confessional statement. Evidence of investigating officer shows that during investigation, he got confessional statement of the accused person recorded by the magistrate. The prosecution could not examine the magistrate B.M. Theron, who recorded confessional statement, as during trial he died. However, the prosecution has examined an official who is conversant with his handwriting and signature of the aforesaid officer, marked him as a PW10.
That you did not read.
Hmm?
PW10 you did
Ase, ase, PW10.
properly.
PW10. So I have not read PW10 because Lordship, he has said that on that day the statement of the witness was recorded, but there is he could not say whether any order is there or not. Just I'm taking to that purpose. PW10. Small evidence, Lordship. I'm sorry for this confusion. Page 30. On 17/7/1997, I was working as a confidential assistant to the Deputy Commissioner Karbi Anglong Dipu. I was acquainted with the handwriting and signature of Bibhu Mohan Theron, who was working as EAC cum Magistrate First Class. On scrutiny of the case record, I have not found the page containing the order dated 17/7/1997 along with the case record. Exhibit 8 is the confessional statement of the accused Balia Mura. Exhibit 81 to 75 are the signature of Sri Bibhu Mohan Theron. From Exhibit 8, it appears that on 17/7/1997, accused was produced before aforesaid magistrate for recording his confessional statement. And on the same day, his confessional statement was recorded after giving mandatory warning to him. Cross. There is no reflection in Exhibit 7 that accused was given time for reflection. There is also no reflection in the Exhibit 7 where the accused was kept for reflection. Just again, I'm taking your Lordship to page 46, Lordship. However, the prosecution examined an official who is conversant with the handwriting and signature of the aforesaid officer, making him as PW10. Exhibit 8 confessional statement shows that prior to the recording confessional statement, accused was cautioned that he was a magistrate but not a police officer, that he would not be remanded to police custody if he refrained from giving confessional statement. And that he was not bound to give confessional statement if did so, it would be used as evidence against him. It does not give exact date on which it was recorded, because in that portion your Lordship will find there was signature where it is written as 17/7, somewhere it is written as 16/7. That apart, order sheet containing order dated 17/7/97 is not found available with the case record. There is also no evidence on record showing that prior to the recording of the confessional statement, adequate time for reflection was given to the accused. In this regard, confessional statement marked as Exhibit 8 is also silent. Confessional statement of accused Balia Mura shows that during the quarrel over the water used in cultivation between the accused and deceased, the accused hits him with a dao. with which he came out from the house, as a result of which he fell down on the ground, and then he left the PO. The accused has further confessed that he surrendered before the Borpothar outpost with dao used in commission of the alleged offense, and the same was seized from him. Paragraph 22. Evidence of PW2 shows that coming to the PO after hearing shouting, she saw the accused going towards his house. Exhibit 6 shows that near the PO there is no dwelling house other than the dwelling house of the accused. Upon perusal of the statement of PW2 recorded under section 161 CRPC, it appears to me that while PW2 reaches the PO, she found one person going towards the house of the accused. Her statement recorded under 161 CRPC is clearly silent that that man was the accused. Exhibit 4 is the FIR which was lodged by one Sri Nogen Soikia, who has claimed to be paternal uncle of the deceased. The prosecution has examined the said Sri Nogen Soikia as PW1. His evidence shows that on fateful night, at the time of occurrence, he was sleeping in his house and occurrence took place at 10:11 p.m. On that night, IC Borpothar, along with his staff, came to his house and informed that the accused appeared and stated that he had killed the deceased with a dao. Thereafter, IC instructed him to go to Thana for identification of the dead body. Accordingly, he went to Thana with IC and saw the accused in the lockup of the Thana. On being asked, he informed the IC that deceased was his nephew. From his evidence, it appears police took him along with the accused to the PO. From the evidence of PW2 shows that just before the occurrence, the deceased went from the house to his paddy field for placing a coca, an instrument for catching of fish. Exhibit 2 is the scissor list by which a torchlight of 2 cells of the Eveready Company and 2 cells and also one dao having bamboo bar were seized from the place of occurrence in presence of Rohit Bora, Ajit Fukan, Chakradhar Bora and Nogen Soikia. The defense has not disputed content of Exhibit 2. From the content of Exhibit 2, it can be presumed that deceased came out to the paddy field from the house. There is no evidence on record showing that the accused sustained any injury. The contents of Exhibit 2 shows that the fateful night was a dark night. There is no evidence showing that PW2 came to PO after hearing shouting with any torchlight or any lamp in the light of which the accused was recognized. For accepting confessional statement, the court needs to ascertain whether the accused was adequate time for reflection or not. I find no evidence on record showing that accused was given adequate time was given for reflection. For the reason stated above, I feel hesitation to believe that PW2 saw the accused fleeing from the PO towards his house. I also feel hesitation to act upon the confessional statement marked as Exhibit 8. From the discussion made above, it has become crystal clear that there is no evidence on record showing that anyone saw the accused person assaulting the deceased or fleeing away from the PO with a dao. The entire prosecution case lies on circumstantial evidence. Now let us see whether the circumstances revealed have form a complete chain of circumstances from which inference can be drawn towards the guilt of the accused or not. So judgment is referred at paragraph 27, Lordship. I am skipping this. Paragraph 28, Lordship, may I see. It is also evident that on being laid by the accused, dead body was recovered, which is not factually correct. Lordship has seen that IO has said they took the accused to the place of occurrence. From the statement of the accused recorded by the investigating officer during investigation, it appears that he surrendered before the police station with a dao used in commission of the alleged occurrence and disclosed that he assaulted the deceased with a dao to death. It also appears from his statement that on the basis his disclosure, dead body was recovered. So regarding recovery of dead body, that is lordship clear by the IO lordship that they took the deceased to the place of occurrence. And the other facts which is disclosed before the investigating officer, that cannot be taken as evidence, lordship. That whether he surrendered or not, those things cannot be. It is evident that on the fateful night, it is first part PW2 saw a person going towards house of the accused from the PO immediately after occurrence. On the same night at about 11 o'clock, he surrendered before the Borpathar police outpost with a dao and disclosed the officer in charge that he came there after hitting the deceased with the same and that the police seized the dao from him. I find the evidence of PW7 and PW9 that on the fateful night, PW9 seized a dao from the possession of the accused and evidence of the PW2 that she saw a person going towards the house of the accused from the PO after occurrence. It is also found that on being shown and laid by the accused, dead body of the deceased was recovered. Hence, I find there was a complete chain of circumstances from the guilt of the accused persons can be inferred. So this is the circumstances. Whereas lordship, the learned trial court has already said that PW2 in 161 did not state that the appellant was seen by her.
No.
Therefore, her evidence was discarded. Again, her statement was taken to complete the chain of circumstances. And the weapon, which is allegedly relied on by the prosecution lordship, it was not proved that it was the weapon of assault because it was not sent for FSL. Whether the said weapon was used to commit the crime or not, that part is still silent, lordship. Because in circumstantial evidence case, lordship, they have to prove each and every circumstance beyond reasonable doubt, lordship. Now the weapon that is not proved as weapon, and the person was seen by although the person was seen by PW2, but who is that person, that is not stated by her during investigation, lordship. So apart from this, lordship, there is nothing on record, lordship. And in my humble submission, lordship, from this evidence, lordship, the learned trial court ought to have released him, acquitted him, lordship. But probably because he surrendered, only for that reason he was convicted, in my humble submission. And the chain of circumstances which is relied on by the learned trial court are not complete chain of circumstance and not proved facts. This is my humble submission.
Good. As far as the confession is concerned, lordship can go to the confession once, at what time he is produced. I'll go to the circumstance later. The confession, there is a stipulation that he was given time for reflection. I'll just point out to that. Lordship will go to page number 70. The confessional statement starts. Yes. Now, what I find is, of course, this is not very proper. I'll go to the original one. The original thing I have taken out, lordship is. It seems it starts at page 8. On page number 71, it's written that on 17/7/97, on the right hand side, 12:45 AM PM to have his confession recorded. So original is also like that, to have at 12:45 PM AM PM, it is 12:45 PM, it has to be PM, to have his confession statement recorded. The letter was given to me, dated so and so, is attached to the record. I have ascertained. I have Not in the proper order. It is not annexed in the proper order. But in the original, it's there. It is attached. I have ascertained that the offense was cited to him. It seems that at 12:45, he is produced for recording his confession on 17/7. He was, the next page, it shows that he was arrested at 5 p.m. on 16/6. That is, Lordship may not go into. Then Lordship will find page number 72, the second paragraph on the right side. I was taken at Thana. I was sent to you from Bokajan on 16/7. Having talked with the accused, explaining to him each of the matters mentioned in paragraph 5 hereunder, and cautioned him that he ought to reflect carefully before making any statement, I have placed him in charge of the peon armed police constable and directed the accused to wait in order that he may have time to reflect before making any statement. That part is there. He was brought and thereafter he was kept in the custody of the peon.
Is it peon or the armed police constable?
In fact, even if it is
Or-
armed, provided that that person does not have anything to do with the instant case, will not affect the confession. Here, even if some armed police constable, doesn't show that he has any interest in the case. So what needs to be seen is that he is away from the influence of the police who are interested in the case. Here, peon/armed police and directed the accused to wait in order that he may have time to reflect. So in a way, he was given some reflection time. Now, this is not clear how much time was given. Then Lordship will see 4. I have satisfied myself that there is no police officers in the court or in any place where the proceeding can be seen or heard except the above named, who have not been concerned in the investigation. So she writes here, they are not concerned with the investigation of the crime, of the instant crime. So he said that whoever is interested are not there. These are foreign police officers. These are not involved in the case. Then 5, he writes, I have not carefully explained arrest to the accused. I am not an officer, but a magistrate, that he is not bound to make a confession. If he does make a confession, it may be used. He or she should not say anything because others have told him to say. Then he should say nothing which is untrue, and I sign my name hereunder in token that these matters have been fully explained, that he appears to me to understand him. Then Lordship will go to the questions. 6, in order to ascertain whether the accused is prepared to make a statement on his free will, he is next examined as follows. Answer in any further statement made by the accused. I am a magistrate, not a police. Do you understand? Yes. You are not bound to make a confession, and what you say may be used against you. Do you understand? Yes. You are at liberty to say what you actually desire and not because somebody told you. Do you understand? Yes. You'll not speak anything that is untrue. I'll speak the truth. The statement of Baliamura, aged 35 years, made in language Assamese, so this was taken. After questioning him on the mandatory requirements, the confession statement was recorded. Thereafter, Lordship will come to, Lordship has already gone to the confessional statement, Lordship did not go again. Page number 17.
Page?
Page number 77. 77, the next page. 8, Lordship will say. After 7, now 8 comes. Brief statement of magistrate, reasons for believing that the statement was voluntarily made, because this is mandatory. Magistrate should not note any complaints or ill treatment or carefully follow the injured noticed on the so-and-so. This is not required. Notice ARPC, bear in mind. when this when the sound confessional statement is recorded otherwise then in discretion in the matter of the court building and during the court the remands so and so. If any stays it appears that a statement shall forthwith. Because here the magistrate has to write. Yes, they're little above that. Lordship will see page number 77. I believe that this confession was voluntarily made. It was taken in my presence and hearing and was read over to the person making it and admitted by him to be correct. And it contains a full and true account of the statement made by him. So as far as voluntariness is concerned, that he has seen, and he writes that yes, I believe that he has voluntarily made. Questions were put, which was the requirement. Then reflection time, how much was reflection time? This is not clear. This is of course by, this is by the ADC, I believe. This is by the, yes, this is by the ADC, the Magistrate First Class BM Teron, that is PW10, who could not be examined because he was dead by then. So here, reflection otherwise is given. Even in the original, it is shown that he was placed in the custody of the peon. And wait, I'll just take out from the away address. Having talked with the accused, the same thing out here in the original, that ought to reflect so and so, but the time is of course not there. He was taken at 16:07 and the same things if your lordship wants to see it from the original 3 and 4, that actually there is some space where he needs to write the time.
Yes.
I have placed him in charge of dash peon and directed the accused to wait in order that he may have to reflect before making any statement. I have satisfied myself that there is no police officers in the court who has interest in the case.
My learned friend, just I'm interrupting. My learned friend, which she read, Lordship, this is the form. And there the magistrate has to put the time, date, everything he has to write in his own handwriting. The other things which my learned friend is reading is the form of the recording the 164 statement. It is the direction to the magistrate that you follow these guidelines. This is the form. This is not actually followed, but it is written already in the form. In every form, it is written.
No, form part is always on the left side. Whatever magistrate writes is on the right side. Form part I have not read. Form part is there. On the left hand side also it's there. Lordship sees the left hand side, it's there. Form part, that I have not read. The right side part which the magistrate writes, this part I have read. Even I know this is the form.
Form.
This is the lordship will see the original. Here 3 and 4. Because form part, left side it's there during the examination. The co-accused and unless in the opinion, safe custody, who are the officers who has to be there and all. Those are on the left side. Right side, these are written by the magistrate. Of course, the blank part he has not filled up. But the fact remains, in my humble submission, this is all that I can see. Reflection as such, it is not a case where reflection at all is not given. He was placed under the custody of a peon who has no interest in the case, and he was given some time for reflection. And on the other day, Lordship has seen in Sharkaria case, the Honorable Supreme Court has said even 15 minutes time is enough for reflection. He should be away from the influences of the police and all. But here is a case where the trial court did not believe the confessional statement. Of course, Lordship can always go through that again. No, there is no bar that Lordship cannot look in look into the confessional statement once the trial court tells that it is bad. Lordship can go into all the merit and the law and the facts of the case, even if there is no appeal by the state and all. But here is a conviction, there cannot be an appeal. But here is a case where confession cannot just be brushed aside. The requirements are being followed. And that too, this is a case where it's a case from Karbi Anglong, and CRPC in a spirit needs to be followed during that time. It is a 97. 97, there was no difference between the judiciary and the executive. So here, in taking that, of course, I don't have any judgment where in those places, even confessional statements needs to be recorded in a spirit without going into the rigors of the CRPC. I don't have the judgments today. But since the requirement is fulfilled, there is no bar in relying on this confession. But then again, the statement, what I find, this is little extra. And the statement is.
Ratan Singh.
Lordship, Ratan Singh is there. Ratan Singh spirit.
It's a state of.
But whether Ratan Singh provides.
State of Nagaland.
State of Nagaland.
Then
But whether.
Ultimately 2013.
It was separated.
That Register General.
But Ratan Singh, I'm not sure whether confessional statement was also dealt with.
Not on that spirit.
Spirit,
Then if it is not separated.
when it was not separated. Confessional statement, when your lordship looks at it, there are certain exculpatory statements. He did not say, I've killed him. He said, I have hit him on the leg, thinking that there will be some mark left on the leg. I left him. I did not intend him to kill him. So this is kind of not inculpatory. He is not exactly admitting his guilt, not to the extent of murdering someone. So this statement involves both inculpatory and exculpatory statement. Hitting him on the leg, he has stated, but killing him, he has not stated. But lordship, whenever lordship can separate the inculpatory and exculpatory, then lordship can very well rely on the inculpatory part and leave the exculpatory part. And here it's not a case where his exculpatory cannot be believed. He in fact had said, yes, there was some dispute with the water. There was a quarrel. He was also holding a machete and I also had a machete, and then we fought. To that extent, like in certain cases, it is said confession can be the sole basis of conviction. Here, that will not be, because here he had not confessed to the killing of the accused. This can be taken, in my humble submission, as a circumstance. This confession. I'll not go to the extent in saying that this can be used for conviction, but this can be used as a circumstance in the instant case. Now, coming to the circumstances. The first circumstance would be that accused himself had brought the incident into light, because he went and surrendered. He was the first person to bring the incident into light, because he went and surrendered before the police personnel, and the police personnel of PW 6 and 7. PW 7 said he came with the machete. I was almost finishing my duty. I called up IC. IC told me to keep him in the lockup. So he came. PW 7 kept him in the lockup and he left. PW 7 left. Thereafter, PW 6 was there in the police station. In charge came. Then in charge took PW 6, the accused, as well as the uncle. I think PW 2. because the police personnel had taken 3 of them. No, sir. He had taken also his uncle, PW 2, no? 3. Acha, PW 3 to the place of occurrence. So the in charge means this PW 9 took PW 7 and 3 as well as the accused to the place of occurrence on the night itself. And the body was recovered from the paddy field. Now this may not be that 27 recovery, because 27 recovery needs certain requirements. It has certain requirements needs to be fulfilled. Now here the body was lying on an open field. Body was not hidden. It was in the public view, but it was dead at night. So dead at night, there was no possibility that someone will come and see. So what I'm submitting is, accused told the police took him to the place where the body was lying. What my learned friend is saying, that it was not accused who led to the recovery of the dead body. It was police who took them. Police has to take him. This is the requirement. He informs, and on his information, police takes the accused to the place of occurrence and the things are recovered. Here he informed, police took him along with the other witnesses to the place of occurrence dead at night. And then the body was recovered. Body was there lying injured along with the machete lying nearby. So this may not be that 27 recovery, but it is a recovery of the body as led by the accused, and that will become a circumstance. So the second circumstance, first circumstance, the accused surrendered. He had brought the incident into light. Second, the accused led the police and recovered the body from the paddy field dead at night. So the body was recovered on being led by accused. Because till then, nobody knew that the deceased was murdered by accused. His body was lying in the paddy field. Nobody knew. So it was the accused who took, and it was the accused who led to the recovery of the body. Third, he was informed, PW 1 was informed by the police at 10:11 at night on the night of occurrence. PW 1 was informed by the police. Police went to his house and informed him that accused had killed Manik. Then he went, so this will be the fourth circumstance where police goes and informs PW 1, the co-villager, no? Yes, co-villager. No, he is the uncle. He is the uncle of the nephew. I stand corrected, Lordship. PW 1 went with the police while recovering the body. Nikki. Or in yes, morning. No, yes, PW 1. It is not PW 3. PW 1, the uncle, the police personnel, IC, as well as the accused went and led to the recovery of the body. The next circumstance, the uncle said that it was the police who came and told us, and then we went and we found a body lying injured on the paddy field. Then the wife, Lordship will see this next circumstance, the wife, when she heard hue and cry, when she heard her husband shouting her name, Bolin, Bolin, Bakuli, Bakuli, she went and she saw a person running towards the house of the accused. Accused house is near the place of occurrence. Now this is, Lordship will see the evidence of PW 3 once more again. PW 2, the wife, 2. The incident, I know accused Bolin Mura as his residence is very near her. They stay almost near to each other. The accused was living at his house by working in the field. Where PW 2 I'm reading.
Page 11.
Page number 11. Shri Nogen Soikia, the complainant, who is the uncle of Manik Soikia, The incident took at about evening while I was living at my residence with her son. The deceased husband was also with us before the incident took place. The incident took place at paddy field in between the house of the accused person and our house. The deceased husband went to place khoka to catch fish at a near distance. He shouted Bakuli Bakuli after half an hour of his going for placing khoka. Then I ran towards the place where I heard the sound and I saw that my husband was lying on the ground senseless. And I saw injuries at 3 places, namely feet, head. 3 places. She, of course, had given only feet and head. Feet and head. Then I saw accused Balia Mura running towards his residence with a dog. And what my learned friend has said and what the trial court has said, she, in her 161 statement, stated that it was simply a person. She saw a person run. But that was not put to her during her cross-examination, of course, subject to correction. I'll just read it again. The cross-examination part, page number 12.
Last 2 lines.
The house of Balia Mura, I'll read the entire part. The house of Balia Mura and our house are very nearer. We came our residence each other. My husband was killed by Balia Mura while I saw at the spot. Now she reiterates the statement. He saw him at the spot. And there was no single person except me on the spot after occurrence. It is not a fact that I did not see the accused Balia Mura on the spot. The aged field, the alleged, I think, no. The field of Balia Mura and ours are very near. He did not work in the field. I did not inform his uncles, Nogen Soikia, because it is far distance at about 1.5 kilometers. And also at present, I could not go as a woman. The accused killed my husband with a dog, which is identified by me, Exhibit A, by which accused committed the murder. Now, the only line, she otherwise reiterates in her cross-examination that he is the person he saw. She said, my husband was killed by Balia Mura while I saw at this spot. And then, of course, one line is there. It is not a fact I did not see accused Balia Mura on the spot. But the specific question that she did not say about Balia Mura in her 161 statement was not put. That you had simply said you had seen a person without identifying. That was not put. Let me go to the IO statement again. IO is at page 28. 28. I think so that even that is there. What was it?
Last line of page 28.
Last
Someone
line.
else had witnessed the incident.
I'll read out the cross-examination part at page 28. When I asked the accused the reason behind the killing, he told me that a quarrel had taken place following the watering of the field and that he had killed the victim as a result. The accused said that the dog he had brought to the police station belonged to him. As informed by the accused, around 7 p.m., the accused had a quarrel with the deceased at the field itself and he had killed the deceased at that place. None else had witnessed the incident. None else. Accused had what the accused said, he had hit the deceased and he ran. Lordship had seen on the other day that while interpreting the witness's statement, we need to see the facts of the circumstances of the particular incident. Here he simply hits, he had a quarrel, he hits and he leaves. He did not see anyone coming to the place of occurrence. Wife was rushing, and then she saw him going away from the place of occurrence. That part, even if that contradiction was not proved, it cannot be said to be proved. Police did not say that she had not stated. I have examined her and she had not stated that she saw accused at the place of occurrence. That part is not there. So the contradiction is not proved. Now the learned trial court cannot bring in 161 statement without proving the contradiction during trial. So that circumstance that the lady had seen the accused at the place of occurrence is not shattered. This is there. This can become a circumstance. The contradiction is not proved, even if there is some. So PW2, the wife had seen the deceased at the place of occurrence running to his house. His house was nearer. Of course, he went to the police station. Where he went, this he only knows. Thereafter, Lordship will go to PW3. The other circumstance is this is an homicidal death. PW3 did not say about the hit, about the injury on the head. Now it is not possible for a witness to see what are the injuries there on the body. Whatever they see as a layman, prima facie, they speak. Wife had said that the injuries were on the head. Lordship had just seen page number 12. I saw injuries at 3 places, namely feet and head. So wife had seen, that can also be a circumstance. Wife saw the injuries on head. PW3, of course, did not see. Perhaps he could not see. He said that it was on the leg and hand. I hope this hand is correct in the original statement. It is not head, because again, page number 15, PW3, Lordship can see whether it is hand or head. Because wife said feet and head. It is the second paragraph of PW3.
Head.
Hand.
Head.
Head. That makes a lot of difference. This typing translation makes a lot of difference. This is head. I just guessed. So he had also seen this corroborates the post-mortem report.
Head, no?
This is head. Because wife had also said. PW4, oh yes, Lord, can again. Lord. PW4, of course, did not see the injuries because by then the police had covered the body by some cloth. So he did not see. That was not required.
Lordship, PW2, just for I'm checking from the judgment, Lordship. PW2 said feet and hand. From the judgment, page 40, your Lordship will find paper book. She said PW2 said feet and hand.
Lordship can see the original
That
there.
will get altered, Lordship. In
Lordship
paper
can
book, it is said hand, PW2 says
feet and head.
feet and head, but in judgment, your Lordship will find she said, so you're seeing injury on feet and hand.
That
Paragraph
not-
8.
Yes, that will not settle the issue. I can check if a Lordship
Paragraph 8, your Lordship will find.
check her original statement.
And about 3, it is said head and legs. But that PW2 again, that part goes. Lord.
Head. With leg and head. PW.
PW3. Leg and hand, feet and empty.
Can I get it? You forward to take and go.
Head over head.
PW2. It's what, no?
Things.
It's the first paragraph on there. Senseless, a head. This is also has to be head. Feet, head. E side. But then recording is was by someone else, and this is head. This cannot be A. This is E. A is simply, Lordship will see this PW2 statement where he is saying that it has N to N ke likhe sahi, husband. A to N ke likhe. Now this cannot be all A. Head no. A to require is no. 1, 2, 3, 4, 5, 6, 7 line from the bottom of the first paragraph of PW2. What I can see is also, that is also head. 7 lines from the bottom of PW2's first paragraph. This seems to be also head, I think. 7th line from the bottom of the first paragraph.
Even in the type copies head.
Type copy.
That
is head.
copy is here in the judgment, Lordship. In the judgment, it is
Okay.
said, page 40, your Lordship will find the trial court who was, while discussing the evidence, here it is written as feet and hand. Page 40.
Judgment will not make any difference.
So far as PW3 is concerned,
Lordship.
just see para 9 of the
Hmm.
judgment. It says head.
Yes, that,
Oh,
It
That
says
is-
head.
it's all bossed up,
Oh, I
yes.
don't understand how to. Of course, in what you are correct, PW2 is
Lordship.
in the judgment is
Lordship.
hand.
PW
But here
9,
it is head. Clearly written head.
yes, it seems to be head. PW 3. Yes.
I leave it up to you,
With the
Lordship. But
injuries
my
on
case
head
is
and
that
legs.
whether I am responsible for causing the injury or not. That injuries, I'm not there.
Yes, this is one of the circumstances. These have corroborated the statement of the doctor. The doctor who said that there are 3 injuries, one on the leg, one on the deep cut injuries at left leg, no? Leg. 2 injuries were on leg and 1 injury on the temporal region, which is 2 centimeters. So 3 injuries were there, and these injuries were corroborated by the evidence of PW2 and 3. This is what my submission is. Now, coming to the point whether he is the perpetrator. Of course, in the confession, we had seen that he had said that there was a quarrel and he had hit him. And then he went straight to the police station and he surrendered. Now, and then one more circumstance would also come. Another machete was found at the field itself and it was seized. That machete has to be of the deceased. So this again corroborates the statement, confessional statement that both were holding machete, that there must be a quarrel, and then that the incident took place. So at best, if there was a quarrel, and he went and surrendered and he told the police, he confessed. Of course, he retracted from the confession, perhaps in his 313. He did not, he said whether his confession statement was put to him. He was working as Sifu Hospital. Yes, false, I made no confession. He retracted from the confession.
Where is the?
Page number 34. The answer to the question number 10, I made no confession. So he retracted, but retraction will not be fatal. In the facts and circumstances, Lordship can always believe this statement. So the circumstances Lordship had seen, accused went and informed the police. He confessed, he went and second circumstance, he led to the recovery of the body. Third, the wife of the deceased saw him running away from the place of occurrence towards his own house. The death is an homicidal, that was supported by PW2 and 3. So these circumstances shows that the accused is the perpetrator. Now, what I can see from the evidence is that there was a quarrel. There is nothing to disbelieve his confessional statement. There was a quarrel. He also had a machete. There was, he said that earlier also he used to stop water being flowed to other fields. So in view of that quarrel and all, sudden spur of the moment, Lordship can convert it by taking recourse to explanation, exception 4 of section 300. That can, in the circumstance of the case, had he fled away from the place of occurrence, had he not surrendered, had he not led to the recovery of the body, the case would have been different. But here, he went straight to the police, told him, confessed, he led to the recovery, everything showed that he was, in a way, his statement can be believed. So, looking at that circumstance, Lordship can convert the matter to 304 part 2. That will be my humble submission. Otherwise, circumstances showed he was the one who had done the incident. He himself said in his confessional statement. So these are my humble submissions.
Lordship, regarding that confessional statement, Lordship, just again, I'm taking to your Lordship, page 70. 70. Page 71, your Lordship will find that he was produced on 17/7/1997. Page 71, top, your Lordship will find. And there is no order of the court that he was produced on that day. It is already reflected in the judgment which I have placed before your Lordship. From the judgment itself appears.
I'll see the order sheet.
Then your Lordship may kindly turn to page 76. This is the statement of the accused. I do not know what is there in the original, but in paper book, Lordship, page 76, down below your Lordship will find signature is put on 16/7. If the statement is recorded on 17/7, how it was signature on 16/7, Lord?
Next page.
Next page again, Lordship, signature on 17/7. So there is the main content which was written on 17 and formalities of placing him under custody of giving time for reflection or not, or those formalities were done on the next day, Lordship, after recording the statement.
Lordship can see the original. It is
Original it is there. I do not know what is there in the original, Lordship.
The confessional.
Yes, Lordship.
It's a small bunch of papers. It's a small file.
Okay,
Etu ako date to ba ki dise?
main contents was 16 of formalities to 17.
Read over and explain, no?
Yes.
So his statement was recorded on 16 and the formalities were done on 17. How that can be, Lordship?
It cannot be 16. 16
It
at
is there in
night.
the record.
Acha, acha. No. I'll just see the order sheet for further clarification. Lordship can send me or the bunch of papers where the positions are there. The order sheet will be there.
There is no mention about giving time for reflection, how many time given. Even then, Lordship will find that the signatures on the formalities are of 17/7, not of 16/7.
I'll see the
So
order.
that cannot be relied on in my humble opinion, and that the learned trial court has rightly discarded this piece of.
Order sheet to our side. 17/7 now, 16/7 to Kiman?
17/7.
97, no? 90. Oh, no. This is not the correct file. I'll just see the other file. Thank you.
And regarding the evidence of PW2, Lordship, one judgment of Honorable Apex Court is there. When the near relative was found injured condition, he went there, he saw that in injured condition. Thereafter, he returned home and did not provide any medical treatment or did not inform others or brought him to hospital. On that ground, Lordship, that evidence of that witness was discarded. Here is similar to PW2. Her husband was lying there in injured condition. She went there. She did not take him to home or hospital. She did not came back with any other person to provide him medical treatment. Nothing was done. Only about 12:30, police came and provided, seen him dead, Lordship. If she actually went there, she has found that her husband is found in injured condition. Then in natural condition, Lordship, it would have been she taken the injured person to her home, or she might have called for help. But that was not done in the present case. I will place the judgment in that connection, Lordship, and in similar situation, her evidence was discarded.
Where's the judgment?
I will place before. I will get the printout and before Lordship. And one more thing, Lordship, I'm paying Lordship. The matter may be kept part and fixed tomorrow, Lordship. Tomorrow, another matter I have before your Lordship. I will do that case also. In both the cases, Lordship, that 164 is involved. I have prepared already one synopsis. I will place before your Lordship. So then it will be more convenient for me to place before your Lordship. That how 164 has to be recorded, what are the parameters, those everything I will place. Retracted confession, everything I will place before your Lordship. In that case also same argument will be there.
But this is a case where it applies in spirit. So again, those
I will-
rigors might not come. But
I will
17,
satisfy your Lordship.
the order sheet, I don't know why it doesn't include these dates. I mean, 17/7.
No, PW10 also said there's no order sheet.
Yes.
There is, yes, 9/7, there is an order. Valia Munda is present. Return after service, IO was not present, but with steps telephonically informed. After 9/7, no orders, then immediately she comes to 4/10/2007.
9/7, date of occurrence is 13/7.
Huh?
Date of occurrence is 13/7.
13/7/2007.
Yeah, 1997.
Oh, to 1997, yes. 1997, no order. There is some orders here. Which
That is what the
pertains
officer
to,
said. There
Huh?
is no order in the report. During trial, that person who came to prove that 164 statement, he said.
there are few orders of 97. These are 10 and 11/97.
There is no order that he was produced before the meeting.
He was sent on bail. Regarding his confessional statement recording, those orders are not there.
So if you check out the evidence of PW10,
Hmm.
there also she has admitted.
Uh-huh. No
she
order
is the-
sheet.
There is
is the-
no order.
is the confidential assistant.
Yes.
Hmm. I don't know where they misplaced the orders.
If that goes, nothing remains. Because the weapon, as my learned friend is saying, he appeared before the investigative police officer with the dao, but that dao is the weapon of offense that is not true. And there is also no material to show that before recording his statement under section 164, Lordship, he was provided legal assistance, Lordship. Because our division bench high court judgment is there. Before recording of 164 statement, he has to give legal assistance. Those things I will place tomorrow in chronological order before Lordship.
No, there are no order sheet, yes.
No order.
Order sheet starts from 4/10/97. Before that, no order sheet. There will be, I don't know why it is not here. This is GR case only.
So admittedly, the statement was recorded on 16/7 and formalities were done on 17/7.
17/7, it's written specifically in the
The
confession that it
contents
was
were
produced
there,
at
signature.
12:45.
read over and explain. That is that part. Page 76.
I'll see if I can find out something more.
It's there, it's 16/7.
16/7, yes. In the original also, it's 16/7, I've checked up. Mistakenly, she must have wrote that. That of course I cannot say. And she writes here in the first paragraph that 17/7 he was produced. Huh?
Yes. Page 71.
Ah.
If he was produced on 17/7, there is no question of recording statement on 16/7.
16/7.
I could have understood that if he put in his every signature 16/7, that mistakenly he has put. But in one person, in one document, in one place he put 17, in one place he could put 16. That is something unusual. Okay. And the IO also says he was produced on 16/7.
And of course, one more space, it was written 16/7 only. I was saying to you, page number 72, I was taken at,
No, he was taken to Thana on 16/7. That
I
is
was sent to you from E,
Bukazan on 16/7.
Bokajan, on 16/7. I was sent to you from Bokajan on 16/7. I was taken to Thana on
The
5.
fact remains, if your lordship see page 73, that I am not a police officer, I am not, you are not bound to make confession. Those things you are explained to him on 17/7. Page 73, your lordship will find right side. And page 74, signature is there, 17/7.
But these signatures are on 17/7, Lordship. This is not, at page number 77, Lordship will see the signature of the magistrate, 17/7, signature of magistrate, 17/7.
Yeah, that is the,
Ah,
except the confessional part,
yes.
16/7.
Hmm,
Even in the original, it's 16/7.
16/7. Cannot improve on that, no answer also. That is why I've said that confessional statement, I cannot rely on solely on that. That becomes a circumstance. And since the circumstance shows that that can be a true picture, so I've submitted that it can be converted.
I will place the judgment why PW2 is not reliable on that aspect. I will submit that. Lordship, may-
But it's, yeah, Ahmed will also that. Also not MSS Jahan and addition. Yes. Tomorrow.
tomorrow, as part.
For Friday.
Obliged, Lordship.
8. Hearing.
How long will take, Chairman?
Lordship, it will take, I have to read the deposition also, Lordship. So it will take some time, Lordship.
11 witnesses, but
Because
short witnesses.
one of us, we have single bench also.
Oh,
Lordship.
yes, Lordship has a single.
So Lordship may take it up tomorrow, Lordship.
Tomorrow now we have already fixed quite a few matters. Maybe next week.
Lordship.
It's a rape and murder case, but then the evidences against the accused are
Is
little
it
less.
POCSO?
Section 4 was there in the charges,
POCSO.
but
Poxo, Lordship, he was acquitted from Poxo.
oh, acha, only 302 is.
302, Lordship. It's no eyewitness, Lordship.
Even the medical evidence. do not
Medical evidence
support.
doesn't support.
Only mother said she saw some injuries on her private parts. Otherwise, her body was floating in the river, and it is a pre-mortem, not post-mortem. It is drowning, anti-mortem drowning, and so there are of course contradictions here. It is said that the accused confessed that he had raped and murdered and threw her body. But then the body was recovered before accused said
Yes.
those things.
And that is only an extrajudicial confession. He was not, his evidence, confession was not recorded.
313 statement,
Yes, Lordship.
starting from page 29.
Yes, Lordship.
Hmm.
He had categorically denied his involvement.
These are in vernacular, isn't it?
No, Lordship, it is also translated.
Where?
Paper book, Lordship.
It's translated.
Translated, Lordship.
It's a
Above
pho-
the
it's a photostat copy.
Vernacular is there, it's not legible, but above the vernacular, there is
Hmm.
translated part is there.
Page 31,
Yes, 31, 32,
33.
yes, Lordship.
These are translated ones.
Yes,
Yes.
Lordship. False statement in the night.
But
This
this
is,
is original only, photostat copy.
Let us see just check up the
it's on
original
desktop.
draft
Yes.
and just compare whether this is the translated copy or the.
I think this is the just photostat copy.
These are photostat copies.
Yes,
That's
She
why-
wrote in English first and then in the Assamese. No, original were in Assamese only. No English answers.
Then
So
how-
the English part is translated and written above the Assamese part.
yes.
Strange.
How?
That cannot be done.
This is a photostat copy.
No, it cannot be photostat because the English part is not here.
English part
The-
is not here, but
From where did this Assamese version came?
It's in Assamese.
original is in
No, no,
Assam.
in the paper book.
Ah, yes. A little strange. And there are no space also. And the answers were little long.
Yes, answers are long, but here the Assamese, well, it may not be legible, Lordship. That is why it's look like shorter.
It seems the answers were in one sentence, but answers are little long. Lordship will see the original, Lordship will understand.
Translated long.
This is clearly in Assamese, huh?
Translated দীঘলকে কৰিছে।
Ah,
এতিয়া
এই
তাই
লাইনটো
অসমীয়া
কেনেকৈ
আনিছে।
দীঘল?
জানিছো তুমি এইটো লাইন কোৱা।
Yes.
মই ভাবিছো পিছত মই ভাবিলো মাৰিছে গোটেইখিনি লেজিবল অহা নাই নেকি জেৰক্স কৰোতে কিবা এটা হৈছে চাওকচোন
Hmm?
জেৰক্সত কিবা এটা হৈছে এইটো ডাবল পেজ আহিছে নেকি
It was photocopy. The signatures on the left hand side.
Ah,
These are photocopy. It shows it's a photocopy.
it's a
Yeah,
But then
photocopy.
from where did this English version came and the Assamese version comes?
Ah,
How is this?
অফিচ
I don't know. This is very difficult to get.
Subsequently কিবা কৰিছে নেকি?
See it like this. Here, same. So, see.
Maybe done
Here,
subsequently there.
here like this.
Judgment of কিবা লিখা আছে।
Assamese also is there, English is there, there's no English. Assamese, there are 3 lines. See question number 5, let us see. Question number 5. No English. English is here. Assamese is just 1 line. Here, question 6 also. English is there.
And the translations are here. The Assamese were translated by the translator. And it was put in the,
Yes, this is being held by the Registry of our High Court.
No, that is the
translations are here.
এইখিনি তাতে লগাই দিছে ন?
তাতে they have superimposed or. Yeah, সেইটো এনেকুৱা কিয় কৰিলে?
কাটি পেলাই লগাইছে চাগে। Maybe they have নহয় কাটি পেলাই লগাই পেলাই পাছত জেৰক্স কৰিছে। সেই white মানে সেইখিনিৰ ওপৰত maybe না part by part এই answer হিচাপত লিখি এনেকে কৰিছে।
maybe this was must.
Yes, Lordship. Perhaps they have cut that portion and then
Photo stated it,
photo stated it.
like we sometimes do in some cases.
After translating it, they have perhaps done that. They have placed it here and by using
Not
gum,
required.
etc. and then they xerox it.
Not required as such. They could have simply translated it and put it.
They wanted to save time.
We may compare both, Lordship.
Questions are quite long.
Ah.
But MS B Sharma, also heard MS Jahan, and addition. When shall you have?
30, Lordship.
There's an order matter.
Obliged.
Item 6, order.
Lordship, we have filed our objection. I don't think it's a case for granting bail, Your Lordship.
That we'll see with the others.
Please, your lordship. Lordship, regarding this matter, we'll be needing paper book. So kindly direct a registry for paper book.
You're not pressing the IA?
Lordship, we were going to, but we don't have the paper book, Lordship. We'll be needing the paper book for it.
The book is not ready. Not prepared. In the main criminal appeal. You're Mr.
A. Sarania.
Heard Mr. A. Sarania, learned counsel for the appellant. Also heard MSB Buyan, learned addition PPR something. LCR second receipts, registry is directed to prepare the paper book. And list the matter after 6 weeks.
My lord.
Like that.
Authority, and according on the donation of land, he requested the authority that engage them. They were engaged in 2005, 7 and 8 and continued up to 2013. From August 2013, suddenly they are stopped for engagement. Though we attend regularly, they have not paid their salary. repeated approaches to the authorities also. They assured us that subsequently not consider our cases, then I approached the National Court. Our specific case is that there are vacancies. Petitioners since 1, 2, and 3 are engaged against compassionate ground. They accrued right because regular appointment and their name earlier has been placed before the authority. Subsequently stated that 3 years has been allowed, not entitled. That period has been withdrawn and it was unlimited at any time to be appointed. In the present review petition, they filed an affidavit. They may be considered. Here is the case, lordships. The respondents taken 2 stand. One stated that they were only engaged against a particular scheme. Scheme has been over, so they were unable to engage. Our case is that we are appointed against the office duty. Sometimes that they were allowed us to work other places, but actually engaged against the vacant post of the officers. Their own documents also stated, lordships, that affidavit also stated, your lordships may play, your lordship judgment may first refer page 28. Paragraph number 2, facts is their lordship, page 30. The learned counsel for the petitioner submits, lordship find it.
Yes.
The learned counsel for the petitioner submits that the petition number 1, 2, and 3 were engaged as casual workers on compassionate grounds on 1/12/2005, 10/1/2007, and 1/5/2008, respectively. The petition number 4 was engaged as casual worker on 1/7/2007, as he has provided a plot of land measuring about so and so katas to the Brahmaputra board, Bosto Guwahati, with request to provide him a job. Thereafter, in terms of the engagement, the petition number 1 was initially paid rupees so and so per month, and other petitioners are paid rupees 2,000 per month. The wages of the petitioners are subsequently enhanced to rupees 4,500 per month. The petitioner paid their wages regularly till the month of July 2013. It will be 13, not 15. However, from the month of August 2013, the petitioners are never paid their wages nor provided any job, despite attending the office of the respondent board regularly. Therefore, the petitioner submitted joint representation to its chairman, Brahmaputra board, Vasishtha, Guwahati, Assam, respondent 3, requesting release the honorary salary. However, no positive response was received from the respondent 3. Therefore, the petitioners, having no option, approached the Eastern Commissioner, Central Government of India, Silchar, for taking necessary steps with regard to the engagement and remuneration of the petitioners. Accordingly, by letter dated 16/1/2015, the Assistant Labor Commissioner, Central Government of India, Silchar, wrote to the respondent 5 on the subject of non-payment of wages to the casual workers. In response, the respondent 5 replied by letter dated 31/12/2013, stating amongst others that due to non-availability approval from the competent authority, the casual workers could not be engaged since August 2013.
Yes, please. I can't hear you.
Planet CC Miss Rita is on next lordship. So matter may kindly be passed over for that day, lordship. Maybe taken up tomorrow.
Six. Again. Elections.
This, it was fixed on. We can fix it on 30. It will be better. Okay, we'll fix it on 30 then.
13.
Yeah, 30.
13/6,
35.
35. June 30. Yeah, lordships.
Right, Mr.
30th of May.
On request made on behalf of MS RDB. Then it's
Days. Problem, right?
Obliged.
Two. Order no step.
None appears for the petition. No steps has been taken for service of notice on columns 1, 2, 8, and 9. Despite giving a second chance on 22/2022. Stop. I got all the petitions dismissed.
Three, order.
I'm for the respondents, the lead petitioner. The request been filed by the state.
None appears for the review commission. Mr. M. Sarabia, the council appears for appeal parties 1 to 59.
My lord,
Stop. Let us give them one last chance.
my lord. Otherwise matter become infectious. My lord, learned pen is not there, that's why very.
This is a matter again on 30 May.
My lord.
Four.
My lord, maybe any other date, not 30 May. My lord.
What is any other date? Say, I'm not sitting single, so I'm finding it quite difficult to fix single bench matters.
I'll be out of session on the day anyway, my lord.
Yes.
Yes, my lord. The petitioner seeking review of the judgment, my lord, at page 24 is the seeking review, my lord.
Where's the judgment?
Page 24, my lord, start from 25. One of the petitioner was appointed as a contract labor in 1988, my lord. In his initial appointment, his date of birth was recorded wrongly as 1/3/1963 instead of 1/3/1969. The review petitioner filed representation before the authority for correction of his date. But the authority did not do so, and meanwhile the petitioner filed a writ petition seeking a direction to the authority for correction of his date of birth. But this honorable court rejected the prayer for the petitioner in the writ petition with the judgment at page 26. At page 26, last portion, the court has considered Annexure 6 of the writ petition. That is the PF statement of 23/22, upon which the learned counsel for the petitioner takes steps that the petitioner has given a period of 2 years, 2 months for correction of his date of birth. However, this court is of the considered opinion that 2 months prior given for correction is only with regard to discrepancies in the PF statement and not any other entries in the date of birth. The petitioner joined the contract labor on demand and will be retiring in the month of January 23. Further, upon perusal of the declaration from the clearly indicates that the petitioner has entered into his date of birth as 1/3/1963. Therefore, in my considered opinion, the petitioner cannot be permitted to change his date of birth at this stage, particularly when he is retiring in the month of January 23. This was the observation of this court. The fact is, before his retirement, the petitioner submitted 3 representations to the authorities. Till passing this order, the authority did not do so. But
Did you take the ground in the writ court?
My lord,
Have you taken the ground in the writ court
review for. Yes, my lord, at page 11 of my petition.
of your writ petition?
Review petition, my lord.
No, was it taken up in the writ court?
My lord,
That you have filed 3 representations and they have not been considered.
yes, my lord, we have filed representation
Where have you taken the ground in the writ petition?
in the writ petition, my lord, it was stated. My lord, he has stated, he has filed a representation before the authority. Paragraph 6 of his writ petition, my lord.
Yes, then
And my lord, what happened? My lord, prior to his retirement, kindly turn to page 18 of my review petition, my lord. Page 18, Annexure C, my lord.
yes,
28.
Sorry, my lord. Page 28 of my review petition. Annexure G, 28.
Yes. 28,
28, my lord.
yes.
Here, my lord, on the basis of my representations filed during my service period, that has been corrected, and my statement of Family Provident Fund was published, my date of birth as 1/3/1963, my lord. It was published on 17 February 2023, prior to my retirement, my lord. I was retired on 28/2/2023. But before my retirement, it was corrected on 17 February 2023.
Where? How?
Page 28, my lord, last portion. Last, my lord, 17 February 23.
Yes,
And the date of birth is at top of the my lord, statement. Date of birth 1 March 1963. Date of joining 1/1/1988. That is correct. This statement was published on 17th February 2023 prior to my retirement.
Who is the signature? Who issued?
This is computer generated statement.
Obviously, when in a computer generated statement, there will be something. Who has issued this?
The authority, respondent number 3 office, my lord.
Yes.
May I please, Your Lordship? Lordship has already rightly held that at the fair ground of service, Lordship as held by various judgments of the Honorable Supreme Court that at the fair ground of service that date of birth cannot be changed, Lordship. In the instant case, we have already submitted earlier, Lordship has perused the said documents wherein he has himself stated that his date of birth is 1/3/1963. And accordingly, on the basis of the said his averments, we have recorded the same. He is not the employee of Oil India Limited. He is the employee of the contractor under the contract labor regulation and abrogation. So we not record, his record is not with. Okay, what happened after this judgment, Lordship? He has committed manipulation of the documents, Lordship, with help of one clerk, Lordship. And accordingly, the same being instead of 1/63, Lordship, he has manipulated the same documents, and accordingly that was detected by Oil India Limited officers, and accordingly SOCOS was the contractor was asked to issue SOCOS notice, and accordingly SOCOS notice was also served upon the petition. So first and
You file an affidavit indicating all this. After that, we'll discuss it.
yes,
What instruction I have received, my
very
lord?
serious offense, Lordship, and
What
we have
instruction
also.
I have received, my lord, on that particular instruction, my lord, I have approached before this court. If anything wrong committed by the review petitioner, my lord, he'll be within
Very
the
serious offense.
within the law, my lord. But meanwhile, my lord, the record may be called for from the respondent office, my lord.
It's not required. I have seen all the documents. Only after that, I passed the order.
It is review petition, Lordship. Very serious.
My
offense,
case is, my lord,
Last paragraph of the order.
Yes,
yes.
That's fixed everything. Nothing much is there.
and he has already retired.
And now I'm told that now the submission is coming from the other side that they are manipulating to
Yes.
documents just on the eve of your retirement.
No, my lord, I have no such
Now they
instruction, my
decided
lord.
also, well, has.
My instruction is, my lord,
file a criminal case against the.
if
petition.
Yeah.
Mr. Shoko's notice.
Yes.
इसी ने क्या मतलब?
He is not our employee, therefore we have initially informed the contractor, and according contractor has issued the SOCOS.
He is not an employee of oil.
No, this is under the contract labor regulation and abolition act. Also, we engage the contractor, and accordingly contractor engaged. There is no master and servant relationship between the petitioner and Oil India Limited. Second page, Lordship.
कुछ पैसे नहीं क्या मांगते पैसे नहीं क्या मांगते तो कुछ पैसे नहीं क्या मांगते क्या को भी तो
This is the same document that is annexed here.
Yes, Lordship.
This is the same document.
Yes, sir. Second page, SOCOS notice, Lordship. 28/2023. It was issued by the contractor, Lordship, since he is working under the contractor. Lordship. And otherwise also this petition also not maintainable.
Have you replied to this Shoko's notice?
No, my lord, we
I'm not.
we have not received the
You
so-called.
take instructions and come back. It's getting more serious.
Yes, Lordship.
Better you withdraw your review petition.
No, I do not know, my lord. We have not received as yet. But if
That's
received,
why
my
it's getting more serious now.
no, my lord,
If you want to
Now-
press your review petition, there's going to be some repercussions on you.
that is true, my lord. As per instruction, my lord, I have not received this notice. If it is yes, so, my lord. So we'll
check
think,
up with your
think
lawyer.
twice. We have not received till today, my lord. It is here. So, computer.
It was served on 28/2/2023.
28. We have not received. My lord, except the one document, everything is, my lord, in my school certificate and Aadhaar card and PAN card, everything is corrected, my lord. School certificate was also corrected, my lord.
He is wake
That
up after serving around several years, he wake up last pay of the service. And
Whatever it is, You made your representations in the year 2022. All those three representations
Yes, my lord.
were made in the year 2022,
22, my lord.
correct?
22, yes,
That
yes.
is just at the back end of your retirement.
That is true, my lord. It is fake.
Number one. Your second ground is that this document indicates that your date of birth has been changed to 1969. Now they're alleging that this has been manipulated by you. And therefore a show cause notice was issued to you. Give him a copy. Do you have a spare copy?
Yes.
Give him a spare copy, let them take instructions, come back.
এখন
Purely on, purely,
আমি submit করেছি
Annexer G, my lord.
which one?
yes we have
This statement is Annexer G, we have annexed.
And that is what
Yeah.
they are alleging. This is manipulated by you. That's why you have issued the show cause notice.
Well, the earlier one which was issued, my lord, I have annexed in page 18, my lord. That is also similar, my lord. Here there is no dates. Page 18, my lord.
Page 18, that is 23 August 2022.
yes
Yes,
Correct.
yes.
Date of birth is
Date of birth is 28 February 1963.
correct.
so
And this, your second document,
Yes.
after dismissal of
this
the
is issued on 17 February.
17th February, my lord, it was on 1/3/1963.
as the lordship
69.
has already dismissed the repetition now he has
69, my lord.
manipulated the said documents with the help of a
1969.
9, my lord.
So these are the things they are alleging that you have manipulated this document.
But I cannot say at this moment if it is manipulated, no, the record will speak all these things, my lord.
Yes,
That is why I am saying, my lord, the record may be called for, my lord.
records they don't have. You are not an employee of
No.
the oil company.
therefore this repetition also not maintainable because
All right, my lord, we'll go through it. We'll take instruction, my lord. In meanwhile, what is happened with the petition?
How much time you require? One, will list it on 30 May.
ওখানে 30? আসান্ন মানে। 30?
Okay.
ডেট অফ বার্থ ঘটে কিন্তু ঠিকই আছে
এরকম কিছু যে এখন document আমি manipulate-
Mr.
দিকে দাও।
DK Das, London Council for Petitioner, prays for some time to enable him to receive instructions with regard to the show cause notice dated 28/2/2023 issued to the review petitioner by whom?
lordship contractor lordship under
the-
whom he was engaged
By the contractor under whom he was engaged. Stop. Praise aloud, this the matter on 30 May 2023.
All right.
lordship ne record my name
Oh, also heard.
কে কলি oblige